नमस्कार। मैं आपका दोस्त सीए मनमोहन, रजिस्टर्ड वैल्यू एंड सिक्योरिटी फाइनेंशियल। Today we shall discuss the journey of home buyers as a financial creditor. So, Insolvency and Bankruptcy Code 2016 was enacted in 2016 by the Government of India to increase ease of doing business in the country. Some laws are consolidated and amended, and path is cleared for reorganization and insolvency resolution process for corporate persons, partnership firms, individuals to be completed in a time-bound manner and for maximization of the value of assets of such persons. So, IBC recognized three types of creditors in order of ranking with respect to their rights and powers as financial creditor, operational creditor, and other creditors. So, financial debt, including a interest on it, which is disbursed against the consideration for the time value of money, is called financial debt. So the amendment in the financial debt or financial creditor is inserted or amended by way of explanation attached to the definition of financial debt, which provides that any amount raised from an LOT under a real estate project shall be deemed to be an amount having commercial effect of a borrowing. कि जो पैसा एलओटी से लिया जाता है उसका एक कमर्शियल इफेक्ट होता है, दैट इज लाइक ए बोराइंग. The expression LOT, the real estate project, have been attributed the same meaning as in Real Estate Act 2006. So we are not going here to define the LOT and real estate project because we are on the other topic. Operational debt would include a claim in respect of goods, services, including employment or any payment due under any law or payable to the government or any local authority. So this is called under the operational. So what is the position of home buyers before the amendment in the code as a financial? Section 6 of the code provides in case of a corporate debtor commits a default, a FC or NOC or the CD himself can initiate CIRP process, either FC, OC or CD. In Colonel Vinod Avasthi and AMR Infrastructure Limited, NCLT rejected the petition of initiation of the insolvency proceeding against the developer on the ground that home buyers cannot be considered as OC under the code. तो यहाँ पर होम बायर को ओसी भी मानने के लिए तैयार नहीं थी कोर्ट बिफोर द अमेंडमेंट, जबकि बाद में इनको फाइनेंशियल क्रेडिटर माना गया. The amount paid to the developer does not fall within the definition of operational debt, as the same is not a claim in respect of provision of goods or services, any employment dues, any statutory dues payable to the government or any local. So these are uncovered under the operational debt as per the definition. However, cases where contact between the parties provided home buyers with a guaranteed assured return by the developer, they were held to be financial. मीन्स जहां पर उनको एक एश्योर्ड रिटर्न देने की बात कही है, तब तक जब तक मकान नहीं मिलता तब तक उनको तो फाइनेंशियल क्रेडिट, बिकॉज दैट इज ट्रीटेड एज ए डेट. In most cases, the home buyers were considered neither as financial creditors and nor as operational creditors, so they can not take any action against the developer. So, IBC Regulation 2016 initially provided the procedure for filing claim forms by the financial creditor and operational creditors only. कि फाइनेंशियल क्रेडिटर क्या फॉर्म में इंफॉर्मेशन जमा करेगा और ऑपरेशनल क्रेडिटर किस फॉर्म में ऑपरेशन फाइलिंग के लिए इंफॉर्मेशन जमा करेगा. होम बायर्स के लिए कोई फॉर्म नहीं था और उसके लिए बहुत दिक्कत आ रही थी, इवन इन द कैटेगरी ऑफ अदर क्रेडिटर्स. So when the plight of the home buyers came to the foray, the IBC amended the regulation with respect to forms for filing claims to include the claims other creditors. तो इनको अदर क्रेडिटर्स में डालने की परमिशन मिली IBBI के द्वारा. सो होम बायर्स का फाइनेंशियल क्रेडिटर्स में कैसे इंक्लूड हुआ? So lack of home buyers across the country, especially in the NCR region, दिल्ली वगैरह में, NCR में, नोएडा में, गाजियाबाद में ज्यादा उत्पात हुआ, ज्यादा होम बायर्स को नुकसान हुआ. They were facing a lot of uncertainty with regard to the delivery of possession of their flats and apartments. So many builder has defaulted in that region, and persons have not get any flat or the rooms which they have booked, and they were in the possession is being delayed by more than 10 years, and helpless buyers had no rescue except to long drawn litigation, because if they have to go to court, that endless litigation is started by the advocates, either in the consumer form or either in the court of law, for the deficiency in the service by the bill. सो इसी सब चीजों को देखते हुए रेरा भी आया था, बट वी आर टॉकिंग अबाउट द IBC कोड रिगार्डिंग द होम बायर्स. The Supreme Court in Bikram Chatterjee versus UOI, Union of India, delivered a landmark judgment protecting the interest of the start home buyers of Amrapali Group in Noida and Greater Noida. So, जो आम्रपाली ग्रुप नोएडा और ग्रेटर नोएडा में थे, उनके अगेंस्ट होम बायर्स को सुप्रीम कोर्ट ने राहत दी, रिलीफ दिया. The court in strong words observed that the home buyers are the victims of collusion of the statutory authorities, bankers, and the developers. The builder was granted land lease by just paying 10% of the lease amount. उसने 10% दिया और सारा का सारा जमीन का चार्ज ले लिया। प्रोजेक्ट वाज फाइनेंस्ड बाय द बैंकर्स विदाउट वेरीफाइंग द स्टेटस ऑफ द लीज ड्यूज। बैंकों ने ज्यादा, उनके पास ताकत ही नहीं है वेरिफिकेशन की, वो इसीलिए फ्रॉड होते हैं। सो फॉरेंसिक ऑडिट में जब ये सब चीजें प्रूव हुई कि डाइवर्जन ऑफ फंड हुआ है, बाय द बिल्डर हुआ है, और इसका अदर अलग अलग कंपनियों के द्वारा डाइवर्जन हुआ है, अलग अलग प्रोजेक्ट्स के द्वारा डाइवर्जन हुआ है, सो सुप्रीम कोर्ट हैज टेकन द स्ट्रॉन्ग डिसीजन। Since home buyers were not classified into the specific category of creditors under IBC and had no rights under the law, so court has felt that in the resolution process, the home buyers are left in the last category of creditors, and it assumes to the gross injustice to them. So court has given the relief of thousands of home buyers by directing National Building Construction Corporation Limited (NBCC) to complete the remaining projects and cancel the registration of Amrit Bhatti Group under NEDA. तो उसका कैंसिल कर दिया और NBCC को हैंड ओवर। In another case, several home buyers who had invested in the projects floated by the JP Infratech Limited (JIL) under the holding company of Jayaprakash Associated Limited had to knock the doors of the Supreme Court to protect their interests against the resolution proceeding initiated by the IDBI Bank under Section 7 of the Code in National Company Law Tribunal against JIL Internal Resolution Professional IR. बिकॉज बैंक सारा का सारा उस प्रोजेक्ट को अपने फेवर में लेना चाहते थे, आईडी बैंक अपने फेवर में लेना चाहते थे, होम बायर्स का नुकसान हो रहा था, होम बायर्स वर ऑन द स्टेक, दे वर द विक्टिम्स। Appointed by the court called for submission of the claims by the stakeholders. The claim of the home buyers were placed under the heading claimed by other creditors, which came in the lowest hierarchy of the financial creditors, operational creditors, employees, and workers. This led to the wide unrest and panic among the home buyers. They challenged the validity of the provisions of the code concerning to their rights. The court observed that IBC does not contain an adequate recognition of the interest of the home buyers in the resolution process, who are the vital stake. मकान उन्हीं के लिए बन रहा है, प्रोजेक्ट उन्हीं के लिए बन रहा है, पैसा उन्होंने ही दे रखा है, और वही बेचारे विक्टिम्स हैं। So, to find a suitable solution, the government constituted an insolvency law committee under the chairmanship of Jati Srinivas. The committee was of the view that non-inclusion of home buyers, either in the category of financial creditors or operational creditors, deprived them of some of their important rights, which right to initiate CIRP, right to be represented on the committee of creditors, and in case of liquidation of the CD, and the guarantee of receiving at least the liquidation value under the resolution. So these rights were deprived of the home buyers. So home buyers were recognized through an amendment ordinance 2018, where home buyers have been brought within the preview of the financial creditors. So since 2018, they are the part of financial creditors. Being part of financial creditors made them necessary constituent of the committee of creditors and will also have voting rights in proportionate to shares of interest in the financial debt owed by the C. The court in the JP case gave relief to the thousands of home buyers by recognizing their claims under the amended definition of the financial creditor. So now home buyers are at par with the bank. They are the financial creditors and they are having the priority over the operational creditor, and the other creditors. So these are challenged by the builders in the court of law by giving the ground of violation of Article 14 and 19 of the Constitution of India. So this was denied by the Supreme Court, and given the judgment in the favor of home buyers, upheld that validity of the amendment and held that there is no infringement of Article 19 of the Constitution. The amendment is in public interest and no unreasonable restriction is placed on the fundamental rights of the petitioners and Article 91G. No person is deprived of property without the authority of a constitutionally valid. So this is the journey of the home buyers in the process. Now is a matter of satisfaction that home buyers are financial creditors. Post amendment to the code, NCLT started the CIRP against defaulting builder in Mrs. Rachna Singh and versus Umang Real Private Limited on the application of home buyer, treating her as an FC. So up now NCLT, NCL court are giving judgments in the favor of home buyer and treating it as a finance. So this is from my side for today. बहुत बहुत धन्यवाद for your patience listening. Just try to make awareness about code and the amendments. Though you are might be aware about this, but this is a small effort from me also. धन्यवाद. नमस्कार.